This is Group 14's presentation prepared by Nico Cognasi, Christina Goulet, Samantha Miller, Matthew Rommelman, and David Williams. Today we'll be covering what is known as the Hot Potato Doctrine. This doctrine establishes that a firm may not fire a present client in order to represent a new client because representing both would cause a conflict of interest. By doing so, the firm is trying to get the benefit of the more lenient conflict of interest rules that apply to former clients. The rationale behind this doctrine is the duty of undivided loyalty that a firm or attorney owes their client. This doctrine began in Picker versus Varian. Here, two law firms merged into one. A conflict of interest soon arose when Varian, who was represented by one of the former firms, voiced concern regarding the fact that this new merged firm would be representing Picker, who was suing Varian. The new firm did not want to lose Picker as a more lucrative client. The new firm was left with limited options of resolving this issue, including dropping Varian as a client. In her opinion, Judge Ann Aldrich stated, "A firm may not drop a client like a hot potato, especially if it is in order to keep happy a far more lucrative client." The court affirmed Varian's motion to disqualify the new merged firm as counsel for Picker since they owed a duty of loyalty to Varian.
Rule 1.3 requires that a lawyer act with reasonable diligence and promptness in representing a client. Comment 4 to Rule 1.3 states that unless the relationship is terminated as provided in Rule 1.6, a lawyer should carry through to conclusion all matters undertaken for a client. Rule 1.16b1 states that withdrawal from an active matter would not be permissible if replacing the lawyer would result in a material adverse effect on the representation. This can be a delay of the matter, extra expense to the client, or difficulty in completing the matter. In Santa Cruz v. Neff, Arthur Goldberg was a client of a particular law firm. He then became romantically involved with Stephania Santa Cruz and employed this law firm to do legal work for her, meaning she was their client. When Goldberg passed away, he left nothing to Stephania in his last will and testament. She sued the estate, and when she did, this law firm sent her a letter terminating representation because of a conflict of interest. When this law firm found out that the firm's two clients, Santa Cruz and the estate, were at odds, it dropped Santa Cruz like a hot potato. The firm dropped Santa Cruz before suit was filed in a transparent attempt to represent the more lucrative client, the estate of a multimillionaire. The court then concluded that Model Rules 1.7a as well as 1.3 precluded this law firm from representing the estate in this matter.
Rule 1.7a covers the conflicts of interest that can arise between two current clients. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or if there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. In a federal case from Mississippi, a lawyer who had represented Allstate Insurance was approached by a prospective client who wished to bring claims against Allstate. Because Allstate's business with the lawyer and his firm had mostly winded down at that point, and there was no indication of new business from Allstate, the attorney accepted the case from the new client. The next day, the lawyer terminated the attorney-client relationship to avoid a conflict of interest with Allstate, and then proceeded to file his new client's claim against Allstate. Allstate subsequently filed a motion to disqualify their former lawyer from representing the adverse party. But would the court find that they were a hot potato client? In resolving the issue, the court determined that while the lawyer's actions were understandable, the attorney-client relationship between the lawyer and Allstate still existed at the time that the lawyer agreed to represent the adverse client, and the lawyer's duty of loyalty owed to Allstate under Rule 1.7 had been breached.
Rule 1.9 also ties into the hot potato doctrine, but focuses on a lawyer's duties to their former clients. Rule 1.9a states, a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client unless the former client gives informed consent confirmed in writing. In Monzon v. United States, Monzon and Morissette are co-defendants in a case involving cocaine distribution. Michael Young was legal counsel for Morissette, who became a government informant and gave information about his accomplice Monzon in exchange for a better deal. This information led to Monzon being sentenced to life in prison. After the ruling, Michael Young denied representing Morissette and submitted an application for a reduction of Monzon's sentence, but the application was quickly denied by the court. The court cited Rule 1.9 and a clear conflict of interest in their decision. The court ruled that the matters of Michael Young's clients were substantially related and their interests were materially adverse due to Morissette's new status as a government informant. Michael Young would have to get a signed waiver from Morissette that allows him to represent Monzon, which was unlikely to happen.
As we have heard, an attorney must act with reasonable diligence in representing their client. And those attorneys cannot absolve themselves of their duties to their client regarding concurrent conflicts by simply dropping those clients like a hot potato. And hiding behind the softer rules of 1.9 involving duties to a former client are not an option. The courts will enforce the spirit of these rules and not simply the dry language. You cannot hide from your duties to your client.